Hello everyone. For today's video, we will be going over our topic for class 9, which is agency. So we'll be looking into what is agency, how is an agency relationship formed. We'll then look at different types of agents, and then we'll dive deeper into what is an agent's authority and duties to both the principal and to third parties. We'll look at different types of these duties. Then we'll look at the principal's duties and liabilities, particularly the principal's duties to the agent, what ratification means, what vicarious liability means, and then finally we'll look into how an agency relationship is terminated. So why is it helpful to understand this? So agency law is a common law concept, and it applies to many different industries and sectors, and it's a guiding force for what a financial professional will be doing as it comes to helping out a client or employing people to work on the financial professional's behalf. So the law of agency relates to the rights and duties of the principal, the agent, and third parties. So I went over what the emphasis on the CPA exam will be in regard to agency, so I won't go into more detail here. Just know that in general, agency relationships come about when one person, who we call the principal, delegates authority to another individual called the agent to act on behalf of the principal. And if the formation of an agency relationship is satisfied according to the legal elements, then the law will actually come in and provide protections for breaches of duties that are now embedded within an agency relationship. So how do we form an agency relationship? So once again, agency describes an express or implied consensual relationship where two parties mutually agree that one party, the agent, will act on behalf of the other party, the principal, in dealing with third parties. So what's important to understand here is the agent, who is the person in which that will act on behalf of another individual. They have the authority to act on the behalf of the principal, and while they're acting on behalf of the principal, they're subject to the principal's control, hence why we delineate between an agent and a principal. So the principal, in this case, must intend for the agent to act on the principal's behalf. So here we see that there has to exist an intent on the behalf of the principal to actually delegate authority to an agent who is subject to the principal's control while the agent is acting on behalf of the principal. So when we look to see whether or not intent exists in the formation of an agency relationship, we look at the principal's intent and we judge it by the reasonable person standard. And the central question that we answer legally on this front is whether the parties have consented to being in an agency relationship with each other. So here's an example. So Bud overheard Harold say, "I wish I had a boat." Bud went to Boat World and told the salesperson that, acting as Harold's agent, he wanted to buy a boat. An agency was not formed because Harold never intended for Bud to act on his behalf. Pretty straightforward and self-explanatory is if in this situation, an agency relationship could have been formed simply if Harold had said, "I wish I had a boat," and not even directly to Bud, but it's Harold just saying it in general and Bud overhearing it. In this scenario, if agency could exist just from these facts, then everyone in the world would be an agent for somebody else when they're doing favors for them. So pretty self-explanatory. What's important to keep in mind here is the principal's intent. So continuing on is conduct by itself is usually sufficient to form an agency relationship. So an agency relationship can be formed by actions even if the parties do not orally or in writing express their consent. So the law will not always require some sort of oral exchange or a writing within a contract to denote whether an agency relationship exists. They could be implied in law even if there is no intent, where sometimes the principal is unavailable and the law will backtrack and say, oh, there was an agency relationship based upon the facts. So we look to see if conduct would make it so that a third party would actually think that a person, when communicating with them, is acting on behalf of another person. So switching a little few gears here is there are formal written appointments of agents, and these are called powers of attorney, and they're legally operable. You may have heard of them. And it's essentially a formal delegation of authority on behalf of a principal to an agent. And there's a few different forms of them. There's the general power of attorney, which authorizes the agent to do anything that may be necessary to transact the principal's legal affairs. So the general power of attorney is very powerful because it allows an agent, if they had the general power of attorney, to actually enter into contracts on behalf of the principal, maybe manage their finances, maybe make decisions about their estate and communicate on behalf of them. It's the all-encompassing agency document. Then there's a special power of attorney, which grants authority for only specific transactions. A special power of attorney may be granted, let's say, if you hire somebody to buy a house for you, right? You only allow them authority to buy a house. You don't allow them authority to decide your financial interests. Then there's a durable power of attorney, which could come in a general or a special form, but it remains in effect if the principal is incapacitated in any way. And generally, all durable powers or all powers of attorney ordinarily terminate upon the death of the principal. So what are the different types of agents? So there are general agents who are authorized to perform all acts relevant to the purpose for which they're engaged. There's a universal agent, which are authorized to conduct all of the principal's business that the principal may legally delegate. So the difference between these two is the general agent is authorized to the purpose in which the principal's intent has already scoped out, whereas the universal agent may actually function almost as a proxy of the principal when conducting anything. But of course, it's limited by legal bars and restrictions. Then we have special agents, and those are engaged for a particular transaction. So think of a real estate broker, think of a CPA, or think of a lawyer. Then we have a del credere agent, who is essentially a salesperson or a broker, but they also guarantee credit to a buyer. And the agent actually is the one that guarantees the third party's obligation to the principal. So assume that you're you're a very rich person, and you want to lend out your money in order to get some income from interest. You might appoint a del credere agent to act as a broker for you, and that agent would go out and solicit people for your extent of credit, right? And what'll happen is if the person that does borrow money from you, if they don't pay you back, then you could go to the del credere agent, and the agent is the one that uses, let's say, an escrow account to manage those funds, and they guarantee the third party's obligation to you. So that would be a del credere agent. So next, let's take a look at how an agency relationship is formed on a legal basis. So the CPA exam has always tested candidates' knowledge of an agent's actual and apparent authority. So be very, very mindful of these two terms. They're very important, especially if you want to take the CPA exam. is all the candidates, they have to remember that the principal is liable on contracts made by their agent as long as the agent has actual apparent or emergency authority. So what is authority? So authority is just a legal term or a legal idea that must exist based in the facts that in the agent, and it's given to the agent by the principal. So the easiest one is actual authority. So actual authority is authority that's conveyed to the agent due to the principal's words or conduct. So think of the principal saying to somebody, or think of a person saying, I want you to buy me a pen for $10. Okay, that would be an example of actual authority in which the first person conveys to another person through words or conduct the right and power to actually go buy a pen for $10, and it binds the principal's liability to the third party. Is, let's say, instead of I give you $10 to buy a pen, let's say I give you $10 to go borrow money from or to lend out to somebody. If the person that goes out finds somebody to borrow the $10, and then the principal just says, oh, sorry, I don't have $10, then that third party would have a right to sue and could actually sue me for even conveying authority onto that second person, my agent, because it binds the principal to third parties. That's a very, very important thing to understand. So actual authority comes in two forms. There's express actual authority, which is the example that I gave, where the agent is expressly told, either by written or spoken words, that he or she may act on behalf of the principal. Then there's implied actual authority. So this is authority that the agent gets from words or conduct by the principal, but it's not explicit, it's not express, it's implied by the words or conduct. So think of the same example, but instead of me directly telling somebody, hey, I give you $10 to go buy a pen for me, what if I just said, oh, I need pens, can you please go get it for me? I didn't tell you how much money to spend. I didn't tell you what types of pens. I just implied specific authority on actual authority onto you, and now you have to just act reasonably to buy a pen that you think that I want. Then there's the second category of apparent authority. So apparent authority is authority that results from a principal's words and conduct or other facts that induces another person to justifiably conclude that an agent has actual authority. So let's not get confused here. Is the first category of actual authority talks about what the principal does and what the agent believes, the agent. For the second category of apparent authority, it's not what the agent believes, it's what a third party believes. So a third party might be engaging with a principal, and maybe the principal and the agent never talk to each other, but the third party, as a reasonable person, may conclude that this other person is an agent of the principal. The apparent authority is what is in the minds of the third parties. Whereas in actual authority, it's what's in the mind of the agent. So keep that in mind. That's a very, very important distinction when it comes to actual versus apparent authority. So these are the duties expected of an agent in an agency relationship. And oftentimes, the principal and the agent enter into a contract that states the terms of their relationship. But apart from a contract, there are these 5 duties that are set forth under agency law. And these would be loyalty, care, notification, obedience, and accounting. They're all pretty self-explanatory, and just read through them and keep them in mind that an agent must act this way when conducting business on behalf of a principal.